I have done some research regarding not just the Tuey Rodriguez instruction that is not yet given in the Karen Reed trial, but has been requested. Why it is not really a good idea in this particular case to ask for that. Also, some things that's going on that I believe are wrong in regarding the second offenses, the lesser offenses that are not included in the indictment, and how that affects the instructions, and when you should give the Tuey versus Rodriguez, the amendment to the Tuey versus Rodriguez, and how the courts have held it, and also what constitutes an actual hung jury. And I do believe at this time that the jury, the multiple times that they have stated that they have not used the words hopelessly deadlocked, but they have used the words exhaustive review of the evidence, and that they are unable to come to a unanimous verdict. Lowley himself has stated he is not doubting that they have given a due evaluation of the evidence. His only reason for remaining and to demand continued deliberation is the time that they have deliberated. It is true that the Supreme Court of Massachusetts and even federal courts have accepted allowing the time factor versus the length of trial as something that they want to consider. However, it becomes a problem on the amount of times the jury has said. Under Massachusetts law, once they have come back, there's a certain point in a time of jury deliberation that the judge cannot continue to demand that they continue to deliberate, because without the consent of the jury. That's what I'm going to be discussing and showing you in cases. So if you're not somebody who's really interested in the integrated details of cases that govern whether or not a judge is doing something that's correct or not correct, and I'm not an attorney. I did graduate with honors from paralegal school, and then I went to law school. Again, I'm not an attorney, but I do like to do researches, and I have found cases where they just don't cite the cases properly. They will cite cases that were reversed on other reasons other than the reasons that they're citing them. For example, they'll have maybe 3 issues in an appeal, and if a case is dismissed or reversed, and they will say, okay, well, this was mentioned in this case, and then they'll use it thinking that that's what caused the reversal, and it wasn't. Misusing citation. So what I will show you here is an older version of the Tuey Rodriguez. This you'll see is 2009 edition. So they did update, but I don't believe that the the most recent cases from Massachusetts Supreme Court, was 2020. There was a most recent case of 2020 that does discuss the Tuey Rodriguez. Commonwealth versus Rodriguez. Now, just because his last name is Rodriguez, that's just a coincidence. So this is a December 4, 2020, almost 2021. Now, I did check the treatment on this just to see if I could find anything where this is just appeal court, this is not Supreme Court. If there had been anything gone further, and I don't believe this has gone to the Supreme Court, but this is not allowed to be cited. But just to show you how the courts use that specific thing, it says, it tells you if a case can be cited, if it's not, going to be used when they reverse something. Okay, so then there is the Commonwealth. This is this right here. There's some important things that's in this particular case, because there's different ways, because this is a lesser offense type of trial. This isn't a one charge, it's all or nothing. There are lesser offenses, but they're not included in the indictment. And so there are some cases that are federal courts that specifically address the whole, but it's not in the indictment issue. And that's what I'm going to show you. Okay. I personally think that Yannetti is the only person at this time who is asking for the Tuey Rodriguez instruction, because once you give that instruction and then they come back, it's over. The problem with that is, and I do not think that he should be asking for this, because if something goes south and they come back with a conviction, he cannot argue on appeal based on these, and I'll put all the links to these cases. He cannot argue on appeal that the judge forced them or coerced them by not allowing them to be done. Once he asks for that Tuey Rodriguez instruction, then if it goes south and they come back and it's not good, he cannot argue that they coerced the jury. They cannot, because he asked for them to go back. But if he was to ask now, we do not want Tuey Rodriguez, we want the judge to just go ahead and declare a mistrial. It's up to the judge, and that's what these cases also show. The judge has the discretion on whether to give the Tuey Rodriguez instruction to make sure that it's not coercive if they give the instruction, because some courts have found, there was one case where they wanted to use the double jeopardy because there was a hung jury. They didn't give the Tuey Rodriguez instruction, and so they're like, look, you can't retry us, because when they said is that the judge not giving the Tuey Rodriguez, the reason the judge did not give the Tuey Rodriguez instruction was because it could have coerced the jury. So Tuey Rodriguez is like a double-edged sword. You don't want to use it. The defense, again, if they demand this instruction again on Monday, and the judge gives it, and it goes south, they cannot argue that you forced them, you coerced them, because you requested the Tuey Rodriguez instruction. The best thing for the defense to do is say, I want a mistrial, because if the judge does not give the mistrial, and then gives the Tuey Rodriguez instruction, and then it goes south, then they will have a good appeal, because of the factor of the reason that they came back and said that after exhaustive review of the evidence, those words, exhaustive review of the evidence, that means they've seen it all. They can't come. Then at that point, especially with lesser offenses included that were not in the indictment, they would have a powerful appeal. Okay, so this is a case where the judge determined the jury completed due and thorough deliberations and gave the Tuey Rodriguez instruction. This was the first time the judge found that there had been due and thorough deliberations. The only thing, again, in this case with the Karen Reed trial is that even Lally admitted that they gave his own words, that they gave due and thorough deliberations. But his only reason was that there wasn't enough time spent. So at this point, he has a good argument to just demand a mistrial. The judge was not required to ask for the jury's consent because it was the first time. So do you see this right here? This was the first time the judge found there had been due and thorough deliberations. Lally himself said that he felt there was due and thorough deliberations. Go back and look at his arguments specifically for them to continue. The last time he says, I'm not doubting that they did due and thorough deliberations. And the judge did not disagree with him. Her only issue was the amount of time. So that right there, they had an argument. He should have presented at this time. The judge was not required to ask for jury's consent. So at this point, after they sent them back in, on Monday, they should be asking for the jury's consent at this point, in my opinion, because amount of times. However, the Tuey Rodriguez instruction that was requested by the attorney, and I believe he's going to ask for it again, is it's going to be harmful if something comes back out. Well, I don't think it will. I think there's people stuck in there. But the Tuey Rodriguez instruction itself was not coercive, where the judge did not depart from the approved language of the instruction or provide the instruction prematurely. So then you have the federal cases. Let me find the federal case. This is the federal case from 1984, United States versus Jackson, Court of Appeals. And what they state in regards to the lesser offenses. So here's the thing about, there's 3 positions that the state of Massachusetts takes when there's lesser offenses. So they didn't give any instruction to the jury on, if you cannot find the person unanimously guilty. So they're basically, without knowing all the positions that the state of Massachusetts holds, there's 3 positions, and one of them is the soft transition, meaning if you cannot unanimously come to a verdict on the first highest offense, then you will consider the lesser offense. And this is where the federal court says that position is wrong. And this case was a reversed and remanded case, because if you have, let's just say even split, 6 jurors who think that she is guilty of the higher offense, this is what they believe the facts equal to. This is their decision. This is what they have concluded after an exhaustive review of the evidence. But you have some that don't agree that she's guilty at all. Then you have some that might, and I'm just speaking as an example, then you might have some who think she might be guilty, but not of the higher offense. You're forcing those people who have said, this is what we believe she's guilty of, to accept that they're guilty of a lesser offense. The instruction given by the court did not allow the jury to consider the lesser offense unless the jury first unanimously acquitted the defendant of the greater offense. Under this instruction, the jury could not consider the lesser offense at all if unable to agree on a verdict for the greater offense. This is the instructions that they're giving in this particular trial. If you go back and you look at the instructions, they break it down. First, you have to vote unanimously on this one. If you can't vote unanimously on this one, then you go to this one. And even though they're not saying if you find them not guilty unanimously, if some of them are stuck that they believe that she's guilty of this, they're forcing them. So it's not appropriate. This case talks about forcing them to a lesser offense. The instruction given by the court did not allow the jury to consider the lesser offense unless the jury first unanimously acquitted the defendant of the greater offense. But as you can see, if some of them are stuck on the higher offense, then you shouldn't be forcing them. Under this instruction, the jury could not consider the lesser offense at all if unable to agree on a verdict for the greater offense. Theoretically, the result would be a mistrial. That's what they've done. They broke it down. It's all or nothing here before you can move on to the next one, basically. Practically, however, in this case, the risk was substantial that jurors harboring a doubt as to the defendant's guilt of the greater offense, but at the same time convinced the defendant has committed some offense, might wrongly yield to the majority and vote to convict of the greater offense rather than not convict the defendant of any offense at all. So those jury instructions they're very important, specifically. And then in this particular case, they're not saying how they're hung up. They're not saying the amount of people. There's a lot of numerical references in these cases on appeal on deciding whether or not a jury was truly hung. They want to, they do discuss in cases where there were a specific amount of people. They said this is exactly how we're hung. And they're not saying why they're hung or how they're hung, but that they are hung. They have exhausted the review of the evidence and they are not able to come. And Lally, of course, says that they didn't say that they weren't able, but at this time, there was no in words at this time in that note. But, and of course, Unetti argued that, he was misrepresenting that. But they're specifically saying they have exhausted the review, period. And the only thing the judge came back with was the amount of time. So I believe that she has multiple times accepted that they have reviewed and gave due diligence. I could be wrong. There were, I believe, 3 different times that they sent them back, and the time factor was the only reason that they said it's not possible for them. But when they used the words exhaustive review of the evidence, and Lowley pretty much defends the jury that he doesn't believe that they haven't, not given due diligence. Okay, so the next case, the Tuey Rodriguez charge, indeed, providing the instruction is ordinarily the preferable, considering what actions, if any, the trial judge took to declaring mistrial to help him determine whether the jury were genuinely deadlocked. Nevertheless, nothing in our cases renders the provision of the Tuey Rodriguez charge to be mandatory. So it's not mandatory that they give this charge, and I just think that the defense should just not ask for it, because if something happens, they're not going to be argued. They're not going to win on appeal. If you ask for that Tuey Rodriguez, you got a strong hung jury, and you ask for that, then you're giving them another chance to find her guilty. And once you ask for the Tuey Rodriguez, you will not win on appeal. I'm telling you, that's what these cases have said. The Tuey Rodriguez charge has a sting and can, if improperly phrased or improvidently given, risk coercion of the jury to reach a verdict with which they are not fully comfortable. But again, if the defense asked for it, he cannot argue that they were coerced because he asked for it. The trial judge, unlike us, interacts directly with the jurors while presiding at the trial. Commonwealth v. Torres, 2009 case. As a result, the judge is ordinarily in the best position to determine whether such cause exists or whether provision of the charge poses a risk of coercion. The decision whether to provide the Tuey Rodriguez charge is therefore committed to the sound discretion of the trial judge. As discussed above, in light of the circumstance of this case, we discern no basis to conclude the judge abused his discretion to determine the jury with deadlock and the declaration of mistrial is justified manifest necessity. The defendant may be retried. Cases are remanded to the county court, where the single justice shall enter a judgment denying the petition so ordered. Then you have this case with this 2017 case, saying that the judge did not abuse her discretion in determining, without objection, keep that in mind, the word without objection, that deliberations had not been due and thorough when the foreperson sent the first note. After 2 full days, which they've already had more than full 2 days in this case, with 11 witnesses, the judge could reasonably conclude 2 hours, and this is the time factor, and 10 minutes of deliberations was not due and thorough within the meaning. And this is what the judge is saying. She's like, well, it cannot be thorough due to the time factor, and that's what she's using, the time factor. But even after they've sent back, though, okay, after they were sent back, like multiple times now, I believe that she should have already got the consent of the jury to send them back in. But I could be wrong, but that's my position. The judge properly concluded, as she did in different words, that the brief time spent deliberations did not amount to due and thorough consideration of the case. Giving Tuey Rodriguez charge implied that the judge had to conclude the jury deliberations were due and thorough in the words of the Section 34. So the defendant argues the Tuey Rodriguez charge was unduly coercive in the circumstances of this case, which I believe if they use it, that's why I'm saying the defendant should not be asking for it. Any effort by the court to persuade the jury to reach an agreement after reporting its numerical split may be interpreted by the minority as an implied command to agree with the majority. We disagree. The amendments to the Tuey charge made in Rodriguez were designed specifically to address the imbalance created when the judge invites the members of the tentative minority to reconsider the majority members to reciprocate toward the minority. There was not the slightest intimation of impatience with the minority, nor any words that could be construed as a threat or even an expression of displeasure. Whereas here, the judge urges further deliberation and effort to agree upon a verdict, and in so doing, her comments are balanced, not slanted. But then you look at the federal case. This is a United States case. Viewpoint of the jurors, which is all that matters in coercion inquiry. The trial judge knew the numerical division. The second note, showing that only one juror was holding out for acquittal, exasperated the risk of coercion. In approving a mistrial after the jury revealed its numerical division, the Mullen court stated it would have been a precarious undertaking for the judge to give a supplemental charge to consider each other's views. That's basically what the Tuey Rodriguez does. It's saying, well, look at the other person's perspective, be a little bit more open-minded. What that does, I don't even agree with the Tuey. I think that the forefathers, um, and you go back, there's a reference all the way back to 1851 with this whole case. And I did go look for that 1851 case. But when a juror is stuck, especially in a case, on this type of case, where it is absolute fraud on the part of the state, and their job, the defense, was, they don't have to prove evidence, but their accusation to the jury specifically was that there's a cover up, they're lying, they're framing her. Okay, so then they have to show that once they've made that accusation, even though they don't have to present, evidence, but they made that accusation. So if they want the jury to accept that accusation, okay, the state shot themselves in the heart. This is my position. On 12:45 a.m., Trooper Paul said, using scientific car data. That was his job to review. He claimed with his associate's degree, he was well equipped to make that decision. He said at 12:45, she hit him and ran him over. And then all those witnesses that said that she was there at 12:45. Then you had the other trooper his role was to review evidence, other types of evidence, and he said that it's not possible that anyone saw her there at 12:45 because at 12:36 she auto-connected to John O'Keefe's Wi-Fi. And now during this trial, they made a great effort to bring in experts to defend Jen McCabe, to say that she didn't make the Google searches, that blah, blah, blah. But they made no effort to bring in any expert to say that there's no possible way that it's not correct scientific data that she connected at 12:36. So that was just an open, oh my gosh, this trooper and all these people said she was there at 12:35, ran him over at 12:45, even though it's inconsistent with what he said it happened at 12:25, that they pinpointed 2 to 3 feet. They pinpointed where his phone was at within 2 to 3 feet. And there was no movement of that phone after 12:25. Then how did he get out of the car at 12:45 for him to hit him? I mean, there's that contradiction. But then you have, oh my gosh, this trooper said that she was at John O'Keefe's at 12:36, and they shot themselves in the heart. So you have very, very serious contradictions that they're not going to be able to get past, no matter if they spent 100 days in that jury room. They're like, I'm done. These are liars. This is a frame job. You will not tell me to convict her. I believe there's some of those people of that jury that's in there, and that's their position. I could be wrong, but I believe there's not guilty people in there. But I do believe that there's some that could be at least one who thinks she's guilty, and there could be a hang up on which offense she is guilty of. And this is important because in these cases, it specifically says that you cannot turn a trial into a whole bunch of different lesser offenses. Whatever's in the indictment, when it comes to these instructions, you can't use them when there's offenses that's not in the indictment. So basically what they did is, you have this discovery, you say, here's your indictment, you got to prove you're not guilty, or you got to prove that we have proved the case, whatever. Here's your indictment, prepare for this case on these charges here. So at trial, when they add other lesser offenses, unless the defense asked for it, then they shot themselves in the foot if they come back guilty. If the defense didn't object, you can't just throw a whole bunch of offenses that we didn't even have a notice of, that's not in the indictment, especially when you're trying to use these instructions. I mean, if sometimes defense do agree with the prosecutor during a trial to go ahead and allow a lesser offense, but that's bad. And this is why Baez won his case. I do believe there's a possibility that there was some kind of neglect there in that. I could be wrong. She could be totally telling the truth. But myself and a lot of people believe in the Baez Casey versus Anthony case, that if he had accepted a lesser offense of neglect, she would have been found guilty. I do believe that. So Baez was smart. He knew, don't even think about throwing in a lesser offense at the end. It's all or nothing. And if the prosecution was like, it's all or nothing, first degree murder or nothing, because what they were accusing could not ever been accepted by society as anything less than first degree. It would have made people angry at that DA if they even thought about asking for anything other than first degree. And so because it was all or nothing, it came back not guilty. But in this case, they're putting a whole bunch of stuff in there, and so these cases, these federal cases, are very applicable to the whole lesser offense. Okay, there's very specific arguments about throwing in lesser offenses and then trying to convince a jury of that in the end. Language that may coerce the jury into a verdict. Let's see. Hang on a second. Let me look at my notes here. Okay, tab number 3. Okay, so down here. When instructing jury must avoid language that may coerce the jury into a verdict. Judge included instruction. Let's go down here. Something the victim's credibility. One count of lesser included. Come on, it's in here. Not converse. Lesser included offenses. Judge provided an answer. This talks about the amount of times that they were told to go back. And in this case, there's definitely, okay, lesser included offenses. Well, 5th tab. Oh, I'm in the wrong tab. My bad. Oh my gosh, I'm so sorry. Oh, the acquittal first rule. This is specifically applicable to this case. It's also inconsistent with the requirement. Now, this is a Massachusetts Supreme Court case from 2014. Jury's verdict in a criminal case can be a general verdict. Lesser included offense is a part of a single charge, not a separate charge or separate offense. A trial on a single complaint or indictment is not a trial on 2 or more offenses. That's applicable in this case because this was a single complaint. They changed the indictment to second degree. Now, they're not on that indictment because I haven't seen the indictment itself that they kept the original charge, but from what it's been reported, it was second degree. So they changed the indictment. She was re-indicted and got a different bond, and it was second degree murder. So identification of applicable lesser included offenses at the time the case is submitted to the jury does not transform the trial into a trial on 2 or more offenses. They have like 4, I believe, total, like 3 different types of lesser offenses that they just threw in on the end. A jury are not deadlocked where they can reach a general verdict that disposes of the entire charge, even if that means conviction of a lesser charge, only where the jury failed to reach a general verdict dispositive of the entire charge, not just a portion of the charge, or the jury hung. The acquittal first rule requires the jury to deliberate as if they were furnished multiple verdict slips on a single indictment or complaint, with one slip reflecting the greater offense and another for each of the lesser included offenses, which they broke it down here. They said that, if you cannot find this person guilty unanimously on this charge, then you consider the next one, which takes away the rights of those who think she's guilty of the higher offense, forcing them to agree on something separate, which is what the federal courts, they address that. The jury cannot file a verdict slip with the clerk and then resume deliberations on remaining lesser included offenses that are reflected on that same verdict slip. So we've rejected the taking of a verdict on anything less than the entirety of a single complaint or indictment, as that would not qualify as the general verdict rule by Rule 27. Verdict as part of the charge with the jury unable to agree on the remainder of the complaint cannot constitute general verdict, because judges may not accept a partial verdict where the jury find a defendant not guilty of the greater offense, but are deadlocked as to the lesser offense. So too should judges refrain from declaring mistrial when the jury are unable to reach agreement as to the greater offense, but may yet be able to achieve a general verdict, talking about the lesser offenses. But the federal courts have addressed this specific thing where they're using this soft transition. See what it talks about. Noting that unlike soft transition jurisdiction, a number of hard transition states accept partial verdicts because juries have confronted and completed determination with respect to greater offense before moving on to the lesser included offenses. And that's why you need to go to federal courts, because they may so federal courts also, by the way, the circuit. So there might be splits in circuit courts. Some circuit courts may not accept the soft transition, but whatever state Massachusetts in, whatever circuit that Massachusetts fall under, their position is what you're going to be for, even though you might find a circuit case on another circuit and it's not going to be applicable. Though it could be used for persuasive argument if you do take it all the way to the Supreme Court. The instruction given by the court did not allow the jury to consider the lesser